Hey, right, everyone. Bear with us while Shannon will just joins up. Hey, right, Shannon.
And everyone.
You are well. Welcome, everyone. I don't know how it's baking hot where I am. I'm hoping it's about to rain because I'm proper fanning around with my camera as well. So, usual stuff. If you're regular, you kind of know the drill. If you're new to us, welcome. The point of this live stream is to hopefully explain the housing law to some level to be helpful, homelessness law in particular, so that people can kind of go and hopefully this is going to help people's situations out. Obviously, sometimes we're not going to be able to manage it. Sometimes kind of questions are just kind of a bit too detailed for us to go into. Um, Please don't put personal data on anything on this channel. I know everyone ignores me, but well, no, I'd say most people ignore me. Some people are actually getting really good at just asking what if questions, and it's really important that you ask what if questions. You get the same answer. In fact, you often get a better answer, and you don't have to share your personal data onto the internet. So I'll just say for those in the chat, yeah, please kind of just bear in mind. Hey, you right, Mark? Just want to say big shout out to Lynn as well, just for kind of the nice message she sent this week. So I'm going to read a bit of that out at some point. It's just nice to have a bit of encouragement doing our stuff. So it seems like obviously sometimes this information does make a really big difference. What else do I need to say? It's not legal advice. So yeah, don't kind of count on what we're saying. Sometimes, yeah, obviously we're going to be a little bit clumsy. Sometimes we're going to have not enough information to give you the right answer. And so actually, the quality of the answer will often depend on the quality of the question. So if you're kind of using that what if idea, so just what if this happened, what would the law be? You're actually more likely to get an accurate answer. Whereas if you kind of spill everything, and I understand why people do that because it's obviously very stressful, but it can kind of means you lose focus on kind of what actually the legal issue is you need to know about. So hopefully that all makes sense. And a little bit of news from us this week. Well, not from us, but from this out there. The local government and social care ombudsman published a report yesterday, and it's all about medical advice, which obviously is a common question we have on the channel. Councils ignoring my doctor's letter or whatever. And in one sense, the law hasn't changed, but it's nice to see the LGO actually kind of say what's what. So if you just Google LGO medical evidence or something like that, LGSCO, I guess technically, but LGO will still come up. I'll just share a little bit of it briefly, just so you can see what it looks like and where to find it. So is it? Do you want to share that one? No, I don't. Hold on. Um, Here we go. This should be the right one. So this is no, it's not done it, is it? Me and technology, eh? Right, this should be the right one. No, it's. Yeah, can you see that, Shannon? It should say Ombudsman at the top,
Yeah.
yeah, because it's my system's telling me I'm showing a different screen.
Issues
So
practical
this,
guidance to council housing officers, yeah?
yeah. So this is the right one. So this is what you get if you Google LGO plus medical evidence, and then the actual report is here. So it's not that long. And if I was clever, I'm actually going to hold on. I'm going to unshare that one, and I'm going to share my PDF version because I've highlighted a bit of it. Well, I've highlighted various bits of it actually. So because again, that's the benefit of PDFs is you can kind of go and actually kind of write on it, so you can kind of come back to stuff later.
And the
So I'm
equivalent of
hoping,
phones, just because not everyone might have a laptop, but the equivalent of phones, if you screenshot it, you can then highlight it on a smartphone
yeah,
as well. So
cool. Yeah, thanks, Shannon. I've just realised that I've said all that, and actually, this PDF hasn't saved my highlights, which is awesome. Um, but let's just go to a few bits of it because I should be able to pick out a couple of bits of it that are just helpful. It could have gone further, and actually, it's just important to say that this is actually looking at. Oh my word, this is nightmarish. So it's actually looking at Part 6 of the Housing Act. So it's looking at medical evidence for things like banding, when you make a housing registry application. But there's no reason why these principles don't apply directly to um, kind of Part 7 as well, so the homes application process. So few bits. So there's this bit here. Council should address all issues an applicant raises in a medical assessment and provide sufficient evidence and reasoning in their decision. This allows the applicant to understand why the decision has been made. So this is important because often what happens is people will tell the council, I've got X, Y, and Z diagnoses, I'm getting treatment from the hospital. And what the council then do is they go to their independent medical advisor, and they basically get a letter which often just kind of negates everything and doesn't really address the right questions. And then the council say, oh, that you've got no problems. So what this is basically saying is that anything you raise with them, anything that's real that you raise with them, should be taken into account in their decision letter. So a non-priority decision, for example, if you've said you've got X, Y, and Z diagnoses, and they don't mention those diagnoses, or they don't kind of mention the kind of umbrella diagnosis potentially, then immediately it's easy to challenge them. And if you then raise it in a review, that will count as new information that would potentially mean that the council has to continue to house you. So there's that bit there.
Just sorry, Mike. Then I feel like it's a question people are going to ask on the timeline bits there. It says reasonable time.
Yeah.
Reasonable time frame.
Yeah. So within part 6, there is no kind of like time limit, whereas part 7 there effectively is. So under part 7, so under the homeless application process, the statutory guidance basically says that the council, once you make a homeless application, the council should only take a few days really, or maybe a couple of weeks in very complex situations to accept the relief duty has been triggered. And then they've got 56 days to carry out their inquiries, and they have to issue the final decision on day 57 unless there's exceptional complexity, in which case they've got another 3 weeks. So so although it kind of says that, I mean, and you often see within local government ombudsman decisions, and there was a whole load this week that got published. I haven't actually had time to look through them yet, but basically more than a couple of weeks for a particular decision is often criticised by the LGO, and that will then lead to a compensation payment for delay, because delay is something you can get compensation for in itself, and the kind of distress and uncertainty that causes. So it kind of, as I say, this is talking about kind of the housing register, but it's the same kind of principles. So give some examples, which are again quite useful. And then it actually gives some case studies later. I'm just trying to pick out a couple. There's a bit on page 4 somewhere, I remember. So this one here is quite useful. So kept a proper record to show how it considered the evidence in the context of the allocation scheme, or in the context of homelessness decision, so section 184 decision, and how it weighed any conflicting evidence. And that's important, because often what happens is you have someone who's got the GP, the OT, the hospital department, social worker all saying, yeah, this person's got some really significant issues. And then the single letter from an independent medical advisor will say, oh, yeah, no, we don't think that's important. And the officer won't explain why they preferred the independent medical advisor over the treating professionals who actually know the patient. I mean, or know the person. So actually, when you look at a lot of independent medical advisors' letters, it says at the bottom in the small print, we haven't carried out an assessment of this person. We haven't seen their full medical records. So it's really quite concerning anyway, as an aside, that councils use these kind of housing kind of medical advisors. So there's a few more bits as well, but then it kind of, so there's a little bit about the Human Rights and Equality Act. And this is just interesting for me because it talks about how the LGO would consider it. So they're saying they can't make a finding about whether the Human Rights Act has been breached or whatever, but they can kind of say that they think it has been. So that can be quite useful. Goes into a bit about remedies, and then you've got a bunch of kind of example case studies, all of which are pretty vanilla. They're pretty kind of common ones. But again, I'm not going to read them all out here, but you can get a sense of kind of what's in that report. So well worth reading. And then you've got kind of summary. So council should consider all evidence provided, keep a proper record of how the evidence has been considered. So that actually might go further than actually just mentioning in a decision letter. There might need to be a separate assessment, which kind of weighs up those different kind of pros and cons about it. Make its own decision and not simply accept the view of the independent medical advisor. That's something that now medical has been criticised a lot in kind of various judgments, where they've basically gone beyond what they should have talked about, and the council's then accepted the now medical decision. Provided the applicant with a written decision, that will happen anyway if the council's following the law within part 7. So that's kind of sort of stuff. So yeah, that, as I say, a good thing. It's good that that's out there. And as I say, I haven't had a chance to look at the LGO decisions that came out in full today, but there seem to be some interesting ones. So if you also go on the LGO website, there's somewhere in it basically allows you to subscribe to their newsletter, and that gives you every decision they make every week, and it's probably like maybe up to 50 across the different departments, and you can kind of see whether they've been upheld and whether they've not been upheld, and that's a really good way of learning stuff. So highly recommend that stuff. Sorry, I've just whittled on a bit too long about that. But anyway, have you guys got any news at all? Anything that's changed in the last week? No worries. If not, if it hasn't, we will get on to questions.
I've got one little bit of news.
Cool.
Which, well, I'll keep it short. But you remember last time we were talking, somebody put a question about can somebody do their own Section 204 appeal?
Yep.
And today I was up at Central London County Court waiting for a Section 204 appeal, which had been listed for February, but didn't go ahead because there were no judges to go ahead. And it didn't go ahead because there were no judges today. But they were very apologetic and they listed it for the 28th of August. But while I was waiting outside court, I was talking to another barrister who was there on his own. And I heard him say to the usher that he was there against an unrepresented opponent who was the appellant. So because I had a little bit of time on my hands, I went over and said to him, how do you find it when you're up against an unrepresented appellant? Because I'd have thought it's a mountain for them to climb in order to get to the point where they can have an argument. And how do you tell somebody the difference between something you disagree with and an error of law, which is what they're talking about in a 204 appeal? And he said, well, between us, the judge and the barrister for the council are under a duty to sort of help the person, but short of teaching them the whole housing law. But anyway, I said to him about this video that we do, the streaming, and I said, we're thinking of making a video about this. Would you be interested in participating and talking about your experiences of dealing with people in this situation? He said yes. So that spurred me on to, I think maybe we do it in a couple of stages. One is we have a basic, this is what you do, like filling in the form. And I suspect that if people do issue their own Section 204 appeals, I mean, there'd really only be 3 reasons for doing it yourself. One is you can't find a solicitor in time. Number 2 is you can't afford you're too wealthy to get legal aid, but you can't afford to pay a private solicitor, which is unusual. Most people on homelessness cases are on benefit. I mean, I don't mean to be generalized, but they tend to go together. And the 3rd reason would be because you're crazy, because you're not going to, if you're just doing it because you think you can, then it's like doing your own root canal surgery. You wouldn't want to do it. So the thing is, if you do get to the stage of going to court, we went into court and the judge said to the guy, where's the opponent? And he said, it's a person unrepresented. And the judge goes, what? An unrepresented opponent? And he said, why hasn't he got a solicitor? And so I think that if you were to go to court, and maybe even if you issue your own appeal and you ask for a direction that it be listed for a directions hearing, you might find a judge and the other side barrister go out of their way to help you find a solicitor and maybe give you some tips about where to go, because they don't want to have, I mean, they don't want to spend a day explaining to somebody what the basics are. So that was quite encouraging.
Yeah,
that's the end of
I suggest we maybe do it on your channel, Will, just as a kind of, I think it kind of ties in kind of more with your sort of angle.
Yes. I should start writing the script very soon.
Yeah. Yeah, cool.
Honest.
Okay, yeah, cool. Just to say, someone just put a question in there, just sharing personal data. I'm not being horrible. I'm just going to delete it and ask you to put it in a what if question. So essentially ask it as if it's about an imaginary hypothetical person. You'll get the same answer, but it doesn't involve you telling the world about your current situation. And again, so I've seen another one as well. Same reason. I'm just going to do the same. So I'm not being horrible. I'm just going to delete it, and then you can rewrite it, just kind of as if it's about someone else. So yeah, hey, you're right, Robert. A couple of comments on there. They're not questions, actually. Just saying. Just heard about a council giving someone a tent and a rucksack, which used to happen quite a lot in the old days. Shouldn't happen. There's been a few big cases. There's one down in Devon or something where they gave like an 18-year-old who I think had very severe mental health issues a rucksack and a tent. It kind of ended up, I think they're under social services as well. It ended up in the papers. Anyway, so yeah, and just, I don't know if I said this already. When you ask questions, if they come in on one of the comments, I will put it in the first person, because then you can't tie it to who said it. But I am going to prioritize those people who have asked questions as if it's a what if question. So that's what we're going to get onto first. And just say someone contacted this week and just basically said that Shannon mentioned about interactions with council, sometimes similar to that of gaslighting. I know so this is a professional who supports someone. Or supports people. I know the legislation. I diplomatically confront council officers with it, and they just ignore us and say us outreach workers have got it wrong, and that, and then just kind of saying that's when you tempted to give up. And then she said, encouragement from you guys last week really lifted me to keep going. And as a result, I got 2 decisions overturned by 2 councils. So yeah, just that person, if you're listening here, well done, good work. Keep it up. Basically, what you generally find is once you've had 1 or 2 victories with a council, they tend to know you mean business, and they'll actually be more likely. It basically gets easier in further decisions and further cases. So let me get up the flip chart, virtual flip chart. So question 1 for this week. Considering that a council has been acting totally unlawfully during all the steps of the homeless application process and stopped communication months ago, does having a solicitor sending pre-action letter give you a better chance to be treated fairly lawfully by the council? For example, not being sent into a temporary accommodation out of the borough, or being offered only private rental accommodation to fulfil the main duty instead of social housing. So the short answer is absolutely yes. So I've only recently started seeing how Will operates. So for those who haven't met us before, Will's a solicitor, and Will's bread and butter. And I won't speak for him; he might say a bit about this in a minute. But his bread and butter is just basically write to legal departments and say you've got a duty to do something. If you don't go and do it, I'm going to go take you to court, basically. And it is very, very effective. So I've seen it in Bedford. So Bedford, I'm from Bedford, worked here all my life really, and I've done it the hard way, it seems, because I've kind of got the outcomes I've got by complaining, going to housing committees, doing all the other stuff, everything except getting a solicitor involved, because I found it very difficult to do so. My experience from seeing what's happened in some situations recently is that a letter from someone like Will just cut through all the nonsense, and the council will basically jump and kind of try and follow the law as best they can. So that's not to say that you can't get good outcomes without using a solicitor. As I say, I've kind of got very good decisions over the years, as has Shannon. But it's certainly a lot easier. So I guess it's why it's so important to get a council to do that, particularly where you've got a situation which has been going on for months, because one of council's best weapons is just to obfuscate stuff and kind of delay things and kind of introduce lots of confusion and stuff, whereas a solicitor would just cut through that with a letter to the legal team. And I've got a story to tell about Bedford, which I'll tell in a few months if I get the person's permission when it's kind of settled. But it was an amazingly good result for very little effort. Just a solicitor writing a letter was all it actually needed. So yeah, but Will, I don't know if you want to add anything to that. I've got something else to say about the last part, but I don't know if you want to say about solicitors and stuff.
Yeah, I mean, I would say, well, I mean, without being silly, it depends what the solicitor's letter says. I mean, councils, if they get a letter from a solicitor which is just a load of rubbish, it won't help. And also, the thing is, for a solicitor to be taken seriously, you have to be able to demonstrate that if they don't do what you're asking, then you will do what you're threatening to do. But I think as long as you've got a well-written solicitor's letter, sometimes it can persuade councils, but usually it won't, because they've made their minds up and they're just doing a damage limitation to think, well, do we want to go to court, or do we? And also it means that the advantage is if you send a solicitor's letter, it gets looked at by somebody senior, whereas the original officer who made the decision has already got confirmation bias, and by making a wrong decision, they're not going to be the person to sort it out. So yeah, it is a good idea to get a solicitor's letter if you can.
Yeah.
Yes, this is probably one of those. Sorry, Mike.
No, you're gone. It's cool.
I guess this is probably one of those situations where, depending on your location, makes a big difference. Like, I wouldn't be sure, but I guess like London councils or Birmingham are probably fairly used to getting pre-action letters, and they're probably still like, well, the demand is so high, take us to court or what. So it's probably going to have more of an impact. And I think we've said this before, and Mike, I know you're sort of a big believer in this, but if you were in, my geography is so bad, guys, a rural area that doesn't have any, I was going to say Shropshire, but I'm pretty sure that's not anyway. You take my point. If it's a smaller area, it's more likely to be effective, isn't it? Effective is not a word. I'm going to stop talking now. Yeah.
No, it's all good. Sorry, I just need to ask you. Certainly there's a big difference between inside the M25 and there's the kind of big urban areas that are used to playing the game with solicitors and kind of councils like in the legal aid deserts. So I talked about this before. Lots of districts around the country have no legal aid funded solicitors in their area, And generally, when you challenge those councils, they're just useless. They're just not used to being challenged. They make an absolute mess of it. That's not to say it's just as difficult to get them to follow the law, because they're just as unruly as kind of other housing officers in London. But certainly they're easier to complain about because they'll generally incriminate themselves just without even because they're just not very good at what they do. Whereas I think it seems to be like London councils, they're kind of just good at playing the game with solicitors, and they'll just try it on. So they say, oh yeah, you're not in priority needs. Then someone like Will gets involved, writes an effective letter, and then say, oh yeah, no, maybe you are, we'll house you. So yeah, just want to say something about this last part here. So these are two examples where a solicitor would potentially be able to help. The first one, as in not being sent to accommodation out of borough, that's certainly something a solicitor could help with. There's some really good case law on that. And I would say actually that's one of the areas which you particularly need a solicitor to realistically kind of make your argument effectively, because it's all in the kind of the way the decision's been made and stuff, and the technicalities. Whereas this last bit, so being offered only private rental accommodation to fulfil the main duty. Now, technically, that would be legal. That isn't challengeable necessarily, unless the private rented accommodation is unsuitable. So private rented accommodation is more likely to be unsuitable because it's generally unaffordable for a lot of people because of the shortfall in universal credit, or if you've got a disability where you need adapted accommodation, because most private landlords don't want adaptations been made. So, but on its own, that's not something you can actually challenge, and a council's legitimately can fulfil the main housing duty through a 12-month short hold tenancy, as long as it's suitable, as long as it's suitable for your household members, affordable, and so on. So yeah, hopefully that answers that question. It just reminded me about another question we had. Hold on a sec, go to there. Yeah, just reminds me of a question I had in through the week. I'll see if I can dig it out because it's quite an interesting one to go into. But yeah, just so number two, interrupt me guys if you've got anything else to say on this one. But number two, I'm supporting a chap that goes between sleeping rough in his car and sofa surfing. He's vulnerable due to mental health and ex-gang involvement. He's not currently fleeing. I've yet to verify him on outreach and might struggle as he's hard to pin down. He has his assessment coming up. I wasn't sure whether the council would put him into prevention or relief. I've worked with for some councils that put all sofa surfers in prevention, but as I see, only other councils are more flexible. I didn't know if anything in the guidance covers this. In this case of this chap, my gut, he will soon be sleeping all the time in his car. And if he gets that, I worry his mental health will hit rock bottom. He might do something to harm himself. As I know, interim accommodation is not offered when prevention duty only. It's only offered. So, good question. The prevention duty is owed to someone who approaches a local authority and there is reason to believe that they might become homeless, or it's likely that they're going to become homeless. They might be likely, I guess, technically, within the next 56 days. And so the interim duty to accommodate doesn't kick in if you're only under the prevention duty. It only kicks in if you're actually already homeless, or you might already be homeless. Now, the idea that sofa surfers, I might just dig out a bit of code of guidance on this one, because so throughout the code of guidance, it talks about sofa surfers as being insecurely accommodated. So there's no way, in my opinion, in my experience, that a council could maintain that someone who is genuinely sofa surfing, and when I say sofa surfing, I don't mean they've got their own room and it's it's perfectly decent, they're paying rent or something, or paying towards the rent, or paying utilities or whatever. I'm talking about proper sofa surfing when you're just sleeping on someone's sofa. That's what sofa surfing is. That person is homeless. And so if you've got a council that is basically routinely saying that person is not actually homeless yet, they're only threatened with homelessness, then that would be challengeable immediately. I'm just going to dig out the code of guidance whilst we're talking, and just to see, I think chapter 6, which is all about the definition of homelessness, I'm not sure if it actually explicitly makes that point, which is probably why this person's asking the question, because it's not it's kind of not laid out particularly helpfully. I'm trying to find the homelessness code of guidance on my desktop right now. If you think I'm completely incompetent, it's because when I plug in my extra monitor, my everything gets shuffled around basically. So I now can't find what I need. So Will and Shannon, feel free to talk whilst I look useless.
Well, I guess there's a rant about verification in there. And there's probably a rant that you don't focus on the sofa surfing and you focus on the fact that they're sleeping in their car. That's the easier argument. And I guess if the council does have like a history of making these decisions, and that's like a wide known thing in your area, that's probably a question to take to the housing committee, where you say, why is this sort of policy? as it were. And even if it's not a written policy, if it's sort of like regular practice, it will probably be written down somewhere. So again, if you wanted to really sort of deep dive into this issue, you could do a freedom of information request and say, can I have your policies on the relief duty for sofa surfers, or just can I have your any information, any documents relating to sofa surfing? And it might be written somewhere. They have something written down advising their workers to not count sofa surfing as homeless. Mike has now got the PDF up of the code of guidance, so
I've just
that's my
searched for
filler.
surfing, and there's only one. It's only got one actual result, which I thought there was more of it than that. So it mentions it in local connection. So effectively, let's go back to basics then. So let's say chapter 6. So okay, under section 175, a person is homeless if they have no accommodation available for occupation in the UK or somewhere else, which they have a legal right to occupy by virtue of an interest in it, an express or implied license to occupy, i.e. is a lodger. So a lodger, sofa surfer is not a lodger. Lodgers, that's the difference there. So, or when living with a relative. So again, it's a slightly different situation. Now there is a bit more about that, which we'll come to in a minute. So a sofa surfer would not have an interest in a property. They would, I guess, there would be an implied license. May well kind of come in here. There'd be an implied license if the person says they're happy them being there. But again, I would say they don't qualify as a lodger in that sense. They're not getting, they're not paying rent or anything. And then at 6.12, so there's some stuff that might be helpful for us here. I'm just reading 6.11 as well, but yeah, so this 6.12 to 6.16 is all about kind of leaving family. So some applicants may have been asked to leave their current accommodation by family or friends with whom they've been living. In such cases, the housing authority will need to carefully consider whether the applicant's license to occupy the accommodation has in fact been revoked, rendering the applicant homeless. Authorities are encouraged to be sensitive to situations where parents or carers have been providing home for family members with care and support needs for a number of years. Blah, 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 blah. I'm trying to work out if there's any kind of like knockout bits that you can kind of quote on its own. I mean, basically, if the friend said, I don't think you should have to do this, but if the friend said, yeah, I don't want them living here anymore, that would be enough for them to be homeless. But yeah, I don't know. Will, have you kind of got any examples here which might help us out here?
No, all I would say is, I'm confident to say that I don't think sofa surfing can ever be treated as not being homeless, or should ever be. It can be, councils will do it, but it shouldn't be. And I don't think any lawyer representing a council would want to stand up in court and say this person isn't homeless because they're sleeping. And sofa surfing is not just sleeping on a sofa. By definition, it means sleeping on different sofas, doesn't it? Because you're sort of going from one friend to another. And that's the surfing bit, catching a wave. The other thing I would say with families is, without going into the law on licenses and things, and whether when you go into a shop, you've got a license to be there, which is why you're not arrested, which you would be if you went in the middle of the night. But different argument. A very common problem with family accommodation is that people go to the council and say, my family want to kick me out or something, or they've asked me to leave. And and then they ring up the family and say, oh, you have to serve 28 days written notice on them to get them to leave, which is absolute nonsense. But, what do you do if a council person rings you up and says it in an authoritative way? I've had that time and time again. And it's just to get rid of people. And so to go back to the prevention duty bit, I think a prevention duty should only be accepted where somebody has accommodation which they're not homeless from, and they might be able to help them avoid losing it. So living in accommodation which you have no right to be there and just you're a guest is not they can't really, there's no way, they can't say, oh, the good news is they've agreed to let you continue to live indefinitely on their sofa. Nobody's going to, might do, but it's very unlikely, and arguably it's not suitable for people to live in anyway, to live on a sofa. So
yeah,
I would say that it should always be a relief duty, or it'd be a relief duty to start with.
So I've just had a really, really quick Google, and I literally just Googled that, and I I'd recommend that to anyone as well. Just Google it in really simple terms and put like law at the end or something. But so the Commons Library, parliament.uk, the statutory definition of homelessness extends beyond rooflessness or sleeping rough, and can include situations where people are sofa surfing or where their current home is unaffordable. And then there's also 29th of February this year, family is a Ombudsman case. Family left to sofa surf for 12 months after being forgotten by London Borough. So that's an LGO decision, and the Ombudsman concluded that the London Borough of Waltham Forest did not do enough to help the family find interim and temporary accommodation, despite deciding at that time that it had a statutory duty to help them.
Shannon, could you either share? I've just made you co-host. If you want to share your screen, you can, or if you want to put that link to that Waltham Forest case in the chat, I'll put it onto the live stream, because I think when you do it, not everyone can see it.
I can share the screen quickly. I'm not on the LGO's website, but it's the local government lawyer one.
Okay.
But yeah, the Ombudsman concluded. I wonder if I could conclude. There you go. Here we go.
Yeah.
So I can put this in the chat.
Yeah.
But a delay in accepting the relief duty. So again, we're talking relief, not prevent. And then if I swap tabs, can you see this one? Can you see the Parliament one?
Yeah. Do you want to? I mean, that link might not fit in the live stream, but send it to me anyway, and I'll get it up on the description afterwards. So but you found it through Google, so that's good to know. And so if I was in that situation, Bedford never even tried that, so that's kind of why I'm a little bit uncertain about where you get the bit for. But effectively, what you do is when you complain, you quote that just from from both sources and say you guys are morons. You don't say that. You kind of say it respectfully, but you basically say you guys are wrong. And if it was me, I'd go back to the housing. As Shannon says, you go to the housing committee and say, your council officers are trying to say that someone's sofa surfing is not homeless. How many people have you done that for over the years? You can ask that question as just it's a coherent question. Be interesting to see what a council would then come back with if you did that. Let's get back to slides. Hopefully that's answered that question. Certainly in some detail. And let's get the next question up, which came in for the week. So just I know some people ask, how do these questions come in? So these are questions that someone put onto any video on the channel, and then I'll get a notification. And as I say, if it's anonymized, I'll prioritize them for the live stream, because it's probably our favorite way of people asking questions, because we have a bit of time to prepare for it. Somebody's banned on social housing list has to be reassessed because they became homeless, was previously already on the list as adequately housed, but now change of circumstances. Will the council consider you homeless and reassess you to a higher band from that date? The homeless application, if approached the council when first received, okay, right. So let me just read that again. So the homeless application, if approached the council when first received Section 21, or when Section 21 expired, or the judge order of possession, or when the bailiff shot. Thank you for the good work, guys. So, the council should, the council should consider you homeless from the point that Section 21 expires. We've done quite extensive bit. There's a video on the channel as well. If you Google on the chat, if you search on the channel for the word bailiff, it will come up with a video about this. And I quote the Homeless Code of Guidance, which basically says it's unlikely to be reasonable to continue to occupy accommodation once the Section 21's expired, which that term reasonable to continue to occupy is a proxy for saying you're homeless. You're homeless if it's not reasonable to continue to occupy your current accommodation. So that kind of gives a little bit of background to that part of the question. Now, it's a good question, this. When anyone can approach the housing register, and if you hit the criteria, you'll get on it, even if you're so adequately housed in theory, in some councils anyway. Just to say, as we always do, the problem we've got with answering these questions on housing registers is that every council's policy is different, so we can never kind of give an absolute. But generally speaking, you might be able to get onto the housing register if you are adequately housed, although some councils won't allow it. They'll say, well, you have no housing need at all. But once you become homeless, you often will bump up the band. So they have to give you a band, because you get something called reasonable preference if you are threatened with homelessness or homeless. So if you're owed either prevention or the relief duty, you should be on the housing register somewhere. It might be the lowest band, but it's still a band. And often most councils, if they accept the main housing duty for you, they'll give you often the second highest band. They tend to reserve kind of the highest band for like emergency kind of domestic abuse or kind of end of life stuff, that sort of thing. But generally speaking, you'll get like band 2 or band B if you are accepted as main duty. And so what happens then is your effective registration date, I think, would be when you first made the application, actually, but I'm not sure about that. It might be when the main housing duty is accepted, actually. Again, it would depend on the council. You'd have to search for your council's housing allocation scheme. If you Google that term, housing allocation scheme, Bedford Borough Council, it will pop up, and just kind of look at how they do that. It will be explained. Generally speaking, I've read a lot of them, and generally they will kind of explain it in layman's terms how that all works. So yeah, so I'm hoping that's actually answered that question. So I don't know, is there anything you guys want to add to that at all?
No.
If not, we'll go to the next one. So if you make a homeless application and you have physical, mental health disabilities, is it okay for the council to make a same-day non-priority decision without carrying out any inquiry? No, that's never okay. Councils will do it all the time, but it's never okay. As we've seen already from that medical evidence LJ report that I've mentioned at the beginning of this, they make the point that the council has to consider everything you raise. So if you said I've got X, Y, and Z physical and mental health issues, they need to make some kind of consideration of that. Now, they might argue, they might try and argue that, well, we didn't need to talk to your GP, but that wouldn't kind of stand up if they try to argue that in court. I don't think, but it wouldn't. There's a case on this. I'm going to do video specifically about this question actually at some point soon when I get around to it. There's a case called IA versus Westminster, where there was a lady, I think it was a lady who had, she basically had some real bad trauma. She'd been tortured, and she was undergoing some sort of therapy with a psychiatrist. And the council I think they just got some stuff back from the independent medical advisor. Specifically, they didn't talk to the psychiatrist, they didn't talk to the GP. And what that case actually said was, once they got that independent medical advice back from the Now Medical or whoever it was, I think it was Now Medical, the council should have then sent that report from Now Medical to the psychiatrist who was actually treating this person and asked them what they thought about it. And that would have given the psychiatrist time to say, what's this Now Medical talking about? They've never even met her. Why are they saying this stuff? Because they, what do they know, sort of thing. But that should have happened. Now, that cannot be done in a day. It's impossible to do that in a day. Realistically, it's not impossible. It's very unlikely to get that within a day. So, but yeah, councils do it all the time. As Will kind of said there, councils can do it in the sense that they can physically do it. They can't do it legally, but they can do it illegally, and they often will do it illegally. So what you have to do there is either, you've got a couple of options. You either challenge the decision through the Section 202 process, which is explained at the end of that non-priority decision letter. It will say, if you're not happy with this, you've got 21 days from receiving this letter to ask for a review of the decision. And you then basically say, you guys didn't even talk to my treating professionals or whatever. That's probably a good enough argument there. You could, you might, in some circumstances, basically complain and say, this is clearly inadequate inquiries. You need to make a decision again. And interestingly, I read this week the LJ can actually make a finding about that. I didn't realize they could. So it is something you can complain about. Or you can make a fresh homeless application the same day and say, well, you made a decision that I'm not in priority because you didn't take in, you ignored my medical issues. Well, I'm making a homeless application again because I have got these medical issues, which you didn't consider, and that they should accept that as well. So there's a number of ways you can tackle it. I guess the kind of route one way of doing it would be through the review process, but there'd be reasons not to do that. If it was me, if I was in that situation personally, I'd make a fresh homes application and complain to the chief exec and involve all the councillors and just basically try and throw the kitchen sink at them, and just say, you guys are, ridiculous. So that's my answer to that question. As I say, I'm going to do a full video about that because it's a really good question. It happens a lot. And as we said elsewhere, the more vulnerable you are, the easier it is to kind of fob you off because, you're kind of you're probably less resourced to actually go and, kind of look into the law and actually get back to them. So yeah, again, Shannon and Will, feel free to, add anything into that. If not, I'll go to the next one.
So the only small thing I'd add in, I guess, is start compiling all the evidence you have. I'd potentially request a new housing officer if I made a fresh application. And yeah, I think just because, you could sort of say within your complaint, like your alongside complaint, that you don't feel safe to, have the same housing officer make the same assessment. But it also just means that people get invested in the decisions they've made. So having a fresh sort of housing officer, if possible, to do that, is one of those things I would do. And I would also potentially look at whether you've got, and not everyone with physical and mental health disabilities will, but to look at if you've got care and support needs. And again, in that complaint, sort of say that that wasn't highlighted if you do. If you don't, then obviously it's not relevant. But I'd look into that sort of thing as well, just to make it as powerful as possible, I guess.
Yeah, cool. So that's all the anonymised questions that we had in through the week. I will get back to the ones which weren't anonymised. Go on, Shannon.
Just because I thought I've just remembered with the rough sleeper in the car, it said about I think it said something like the risk of harm to themselves. I know you probably are already doing this, but make a safeguarding alert. It might not go anywhere, or it might not seem like it will go anywhere. But if you've got those concerns, just make a safeguarding alert because it's logged. And obviously that's going to ultimately try and protect that person further down the line. But it is helpful to do that. I just don't think we said it earlier. Sorry, I'm jumping.
No, we didn't. That's yeah. Well, good shout, Shannon. So yeah, so we're on to the anonymised questions from the live stream now. So this is the first one here. Well, that's not done properly. What's going on there? Oh yeah, because I put the cursor in the wrong place. There we go. So a friend has been offered a job. I believe UC will take away 55p in every pound earned while still waiting and looking for proper council housing. Any steps I should be aware of? So obviously with universal credit, you can claim universal credit if you're in work. My experience of universal credit is that it's actually there's a real sweet spot. So if you work in like 16 hours a week or something around that in that region, you get a good deal basically. In one sense, it's good at supporting people back into work. And so taking 50, I mean, if it's taking 55p away in every pound, it means that they're actually getting quite a lot probably. It just depends on the sums. I don't know how, I don't know what kind of. Bottom line is, my guess is they would be able to afford private rented as another option. Now they can still wait around and try and get social housing, but that they should be in a. As I say, in my experience, I'm not an expert on this at all, but they generally have got that kind of flexibility financially.
It's also they only take away 55p in every £1 after you've earned a certain amount. That amount changes depending on what category of UC you're sort of in and stuff. So potentially, I think you can earn like £600 odd before it starts being deducted. And that's then, so you get the £600 odd then plus your full universal credit claim. But it does depend on whether you get like housing element or housing benefit. But in terms of next steps, I'd say talk to your work coach. They'd be able to best advise you on how it's going to affect your claim. And I guess your work commitments as well. But they're probably going to say, take the job. It's often easier to find a more appropriate job when you're already in one. So I guess that's what they are likely to say. But that's, yeah, put it in your journal and talk to your work coach.
Yeah, cool. Next question. I think I'm just getting this all right. So if a council has had a Section 21 agreed with a landlord to no end date, use I'm not sure if I'm reading that right. To use as an unsuitable flat as temporary accommodation to allocation team find something. Can they do that for tenants have multiple medical problems? And the team has said it's unsuitable. So I think what's happened is that the council is basically given accommodation to someone as maybe as I'm not sure if they're using it as temporary accommodation or what, but the housing team themselves are saying, yeah, we have realised this is unsuitable. We're trying to find you something better. Now there's a case with Croydon. Imam v Croydon maybe will help me out with that one, but basically where this is essentially what happened. Croydon Council they accepted. We get this isn't suitable for you, and we're trying to find something as best we can, but we haven't got anything. And it went to whatever court it was, and the judge said that's not good enough reason not to follow the law. So Croydon effectively had to reallocate resources or whatever they needed to do. It was a duty they had to do, so they had to find out a way of doing it. So I think I've read that question right. Again, Shannon and Will, if you think there's a better way of reading it, let me know.
There's an alternative way, I think, which is if I just quickly do it may be this is the problem with the prevention duty as well, is that say somebody presents to the council and they've had a Section 21 notice which is due to expire or even has expired, the council could call the landlord up and say, would you mind not evicting them for the time being, and we'll try and find them somewhere, but could you give us a bit of time? And that could turn into a month, a year, 2 years, and you're still stuck there. And the council is saying, well, they haven't issued proceedings, so you're not homeless. And the issue there is really, and it would be difficult to challenge that, because the test on homelessness is whether it's a valid Section 21 notice has been served and the landlord is likely to issue. Yeah. So if the landlord has said they're not going to issue, then that's one, you're stuck on that. But if it is unsuitable, then you're homeless because it's not reasonable for you to continue to occupy. So I would say go ahead and make an application and say, well, I haven't applied because I'm going to be evicted. I'm also applying just because I'm going to be evicted. I've also applied because this is unsuitable, and I want you to help me that way.
Yeah, cool. Okay, yeah. So, and just to kind of lay out, I think you just kind of mentioned there, Will. So, this is 6.35 of the Homelessness Code of Guidance, which basically tells councils how to follow the law. And so there's three criteria that might be met that would mean that you're not that you might be homeless. So so just to remind everyone, this term here means is a proxy for being homeless. So if it's not reasonable to continue to occupy accommodation, then you are already homeless. So basically, the Secretary of State considers that where an applicant is effectively been served a valid Section 21 notice, and the housing authority is satisfied the landlord intends to seek possession, because sometimes landlords just serve them for other reasons, and further efforts from the housing authority to resolve the situation to persuade the landlord to allow the tenant to remain in the property are unlikely to be successful, and there'll be no defence, then you would, in effect, it's likely you'd be homeless. So it doesn't go quite far saying you definitely would be, but it says you likely would be. So yeah, as Will kind of said, you would have situations where the council kind of, that part of that prevention work, they talk to the landlord and say, look, can you hang on to them for a bit longer? Which, as Will kind of said, that could then end up rolling on for way too long. That could put you in a difficult position to actually challenge it, because technically the council's following the law. But then, as Will says, but if it's unsuitable for another reason, then you don't have to make the argument. It's already unreasonable to continue to occupy. Cool. So where are we up to? I'm just going to put, so Shannon just sent, she sent me a while ago, the LGO case with Walden Forest. So I'm just going to put that into the live stream chat. It'll be in the description of the video as well, but just for reference. And let's get back to the questions and see what question is next in the live stream. So I haven't got a clue about this one. No, hold on. So if a repair order is submitted before the Section 21 is served, I think, but after a call from the letting agent informing about the Section 21, does that invalidate the Section 21? So it sounds like the letting agent has rung up saying you're about to get a Section 21, but the repair, yeah, Will, I don't know this one.
I think the question is, does the if I'm understanding the question right, does the repair notice have to have been served before the notice in order to invalidate it, or before the court case? And I think the answer is before the court case. I'm just checking that, because there's a checklist. If you go to the Nearly Legal website and you just type in Section 21 checklist or flowchart, there's a checklist. I'll just quickly go to it. I think I can get there quickly enough to do it.
I can put it up on the screen whilst you're doing that.
While you're doing that, I will just check, because there's a question sort of, did this happen? Did that happen? So let me just check the repair one. I'll just quickly search for the word repair. Oh, of course.
This is one of those situations, isn't it, where like a housing officer at the local authority is probably going to be really helpful. So you could potentially take it to them, and if it gets them out of a duty, they're likely to try and sort of not be on your side because they're not against you. But like they're likely to help you out more. I'm really fumbling my words, everyone, tonight. I'm so sorry. Yeah.
You're all good. No, it's all good. So Will, this is the checklist that Will's talking about. Let me know if you can't see it, guys, because it looks like it's sharing the right one. As you see, I think it's like 17 pages long or something ridiculous.
Yeah.
So Giles Peter, 15 pages. So Giles Peter, who writes it, I mean, he basically makes the point, like, this is free advice, so don't rely on it. It's not legal advice, but he's just trying to be really helpful. And we're not going to go through it right now, but unless you can see something, Will, which I can just go to.
If you go to page 10, the question is, has the council served an improvement notice or emergency remedial notice in the last 6 months? And if yes, the answer, the Section 21 notice is invalid. So I think that if you went to court and you'd got the notice after the if the emergency remedial notice had been served after the notice, it can invalidate it backwards. But please, can anyone who knows correct me if I'm wrong? It's really unfortunate, and I'm not going to go down the rabbit hole particularly, but notice on page 10 there, it's got particular wording. Have they served an improvement notice? That's a capital I, capital N, or an emergency remedial notice. Now, the reason those have got capitals is they are particular statutory documents. It's not just a letter saying this place is terrible, what you're going to do. That isn't a valid notice. And a lot of councils are very wishy-washy and they won't sort of serve a formal notice. So the council could have written to the landlord saying this is awful, but that wouldn't invalidate the notice. And sometimes you'd have to, I mean, the fact is most tenants who are in properties that are in a terrible condition don't want to stay there anyway, so they're not too bothered about defending the case. But you could, in theory, have to judicially review the council to serve the right notice in order to stop your landlord being able to evict you.
Well, so looking at that, Will, just a bit below it. So because what's happened in the situation, if I understand it correctly, is the letting agent has rung the tenant up saying, hey, landlord's going to serve you a Section 21 notice in the next few days. And then they immediately basically make a complaint about the condition of the property to the landlord in writing.
Yeah.
Then, I mean, I'm not, and then the landlord's then got to do this bit, respond within 14 days. I mean, as I say, I'm not familiar with this document at all. I've never used it myself because I generally kind of work with people that when the eviction's already happened. But for those that say, if you saw me search for it, nearly legal Section 21 checklist, you get this document, and you might be able to find some stuff in there that's going to be helpful.
Sorry, Shannon, go on.
No, you go on.
Well, just to say, the bit I was looking for is at the bottom of page 10, there's a red box, and that confirms that if the notice is served before the possession order is made, the Section 21 becomes invalid. So really, you've got right up until the hearing or when a possession order is made, but that's only the notice served by the council. If you look back, the bit about you putting it in writing to the landlord, that's got to be before the notice. But I think you've still got to go to the council after that. So it's best to go to the council and ask them to either rehouse you, and that could be part of their prevention duty. If they're taking it seriously, their prevention duty would say, we need to serve a notice, and then he won't be able to evict them. But as I say, that may be a sort of mixed blessing because you may want to get out of there.
Cool. So, I mean, hopefully that's... Sorry, Shannon.
No, I can probably throw a spanner in the works again. But I think at the top of that, it said it was right as like 2021. And I know with repairs, there's been a lot of guidance and law change around repairs and social landlords and that whole process. So the Housing Ombudsman has done loads of like reports, and the laws changed around repairs after sort of shock, Awab Ashok. So what I would just say is definitely use that, but also go onto the Housing Ombudsman and sort of look at their guidance, because it might just be the thing is, it will only be better, I think, in regards to this situation. So, but you might as well sort of get as much information as you can. But I haven't read all those documents, so I can't be more helpful than that. Apologies.
Yeah, no, I mean, well, as I say, there's obviously gaps in our knowledge. So I'm hoping there's some stuff in there that the person can kind of maybe look into a bit more, or kind of this maybe some things they can kind of pursue a little bit more that might be helpful, without us being able to necessarily give a very clear answer on that. But yeah. Okay, so I'm just trying to read if this is a question or a statement.
Yeah, a lot of questions tonight.
Yeah. How long are you guys around for? I think that's just basically it. My friend recently living with elderly uncle. You confirm that if the uncle asks him to leave, then my friend is homeless and will get the council to help. So So I mean, yeah, I mean, so I don't think you should need a letter from the uncle to do it really, but let's just do it just to be safe. So yeah, a letter from the uncle saying actually I don't want this person living with me anymore, my nephew or niece, whatever it is. Then and that's that's genuine. They're not just kind of the council would sort of try and look into that in a bit more detail. They can do that, but that would enable the person for that. There'd be reasons to believe they might be homeless. They can then make the application. Now they still need to be in priority need or might to potentially be in priority need for the council to actually have to do a lot, but it's certainly going to start that process. So next question, which is definitely a question, is this one here. How is it acceptable for a council to refuse a person accommodation 4 times and sending said person back to sleep on the emotionally manipulative ex-partner? So emotional manipulation probably would may well meet the definition of emotional abuse, which would be domestic abuse, which means that the person is homeless. So it's the answer. The answer is it's not acceptable. But unfortunately, because there aren't enough people challenging councils around the country, you do get councils that just break the law in broad daylight. So, I guess part of what we're doing in these kind of live streams is trying to equip, professionals to kind of take on their local council or, members of the public who aren't necessarily going through it right now, because it's a big ask for people to, to kind of challenge their council whilst they're also in the midst of it. But certainly, if, once you get housed, I would, strongly suggest you could do a lot of good by kind of getting stuck in and challenging the council. Certainly, that would be something that you could complain about, and the LGO may well find fault. If you look at the LGO again, if you just Google LGO report on domestic abuse, you get 2121 report, which basically it makes a number of really good statements. One of the statements it says is that local council's default position should be to believe people who disclose they've been abused. So if you're going to a council and saying, my partner's emotionally manipulating me, and kind of, you might need to give a little bit more detail about that. Needs to be done confidentially, so the council needs to be very careful how they handle it. But their default position should be to believe you. However, we've seen, since the Domestic Abuse Act came in and the law got better, we've seen councils, just kind of act almost worse than they were before. So it's not acceptable. It's terrible. I guess, certainly personally, I would challenge it. Any time I saw it, I'd be jumping on the council and sending a complaint to the chief exec, kind of quoting these bits of LJ reports and guidance and stuff. The whole of Chapter 21 of the Homelessness Code of Guidance is about domestic abuse, and there's also guidance on the Domestic Abuse Act, which would kind of give a bit more detail to just kind of how you would, what kind of terminology to use to kind of help you articulate things as well as you can, and kind of use the kind of, the technical terms they use to kind of explain your case. But yeah, that shouldn't have happened. And I've certainly worked with many victims of domestic abuse who have got very large payments, compensation payments from the local council, and it's not that difficult to argue a lot of the time because the law itself is very clear on it. So yeah, there's a lot. I'd imagine I haven't done it here, but if you Google LGO report domestic abuse, kind of like one of their everyday reports they do, there's probably going to be loads of them where they kind of unpick cases of this sort of thing happening. So next question. But by the way, guys, just to help our analytics whilst I remember, if you want to just like the video, if this is useful, like the video, give it a share. If you haven't subscribed already, do subscribe because you'll then get notifications about when we're live. I'm pretty sure also if once you've subscribed, there's like a thing which says like there's like a bell symbol. If you tick that, you'll get notifications. So some people don't get that by default. Anyway, question 9. How long does it take for the relief duty to kick in after making homes application? I know of somebody made an application in November and relief duty didn't kick in until February, the end of February, I think that's saying. So my guess is that is too long. So unless it was a ridiculous, because all that the council need to be satisfied of is that you are homeless and you are eligible. And homelessness is generally pretty straightforward. It's not going to take, it's going to take hours rather than weeks to ascertain most people are actually homeless. It might, I guess, be a little bit more complicated with eligibility. So if you come through the immigration system and you now maybe got settled status or whatever, then maybe there's a bit more to it. But certainly I've seen LGO decisions, they're talking that, anything over a couple of weeks really is going to be too long, and they will start recommending a small payment for every month of delay there. So you could, again, if it was me, I'd complain to the chief exec and say I made an application on this date. The council didn't actually get around to accepting the relief duty until this date. That's too long, trying to think where you would find if there's anything helpful the LGO actually say. You might, I certainly quote LGO decisions that I read loads. That's, certainly when I started off, that's all I did. I just quote a decision here saying this is what happened at this other council and you've done the same thing, and that's why you're wrong. So you might be able to find some stuff on now. I can't think of anything off the top of my head, any cases off the top of my head. But again, I might have a Google around a little bit later on in this live stream just to see if I can find something. But if you just Google LGSCO, technically, decisions on relief duty, you might well get some stuff. And maybe that word delay as well, if you put that word in as well, you might well get something quite helpful. So, yeah, hopefully that answers that question. Next question. Again, this is out my area of knowledge. Is it a revenge eviction if the landlord tells you to expect a Section 21 exactly 6 months and 1 day after a repair ticket is closed? Yeah, it's not surprising. But yeah, is that? I mean, my guess is the answer is no. But Will, you probably know better than me and Shannon.
Right. I think the answer is it's difficult to tell, isn't it? Because if they were going to sell their property and it's just a coincidence, then no, it isn't. But if in the next bit of the notification they say, and this is because you did the complaint about the disrepair, then that arguably would be. But, and forgive me if I'm wrong here, but I don't think that it's that significant, because the problem with no fault evictions is that they can do a revenge eviction. And so it doesn't make much difference.
Yeah, because my understanding was because maybe like 8 years ago, they were looking to bring in legislation to ban revenge evictions. I know Australian law is not too dissimilar from our law, and they do have like a ban on revenge evictions there, but in Britain we didn't go for it for whatever reason. It's
really difficult to enforce without going and taking up too much time. But if a landlord says, no, it's not a revenge eviction, my grandson's coming and he needs to live in this house, so I need it back so he can live there, and then you find out a year after that they lied and the grandson is still living abroad or something. The question is, what do you do with the landlord? What's the offence? Is it a criminal offence? Because it's really difficult to enforce, because you wouldn't really want to send the police round, or maybe you would actually. So they've tended to shy away from looking into stopping revenge eviction, but just making Section 21 no fault evictions and banning them, which now Labour have got to wrestle with that one, because the Tories completely failed, because they've got too many landlords paying contributions to them. Yeah, I slightly off topic. I'm pretty sure the Labour's got their first kind of parliamentary suspension from someone who didn't declare that they were a landlord. Yeah.
Oh, yeah. Man, anyway, right. Let's not talk politics too much today. So next question has so someone has 100k in the bank.
No.
But she's not worked for nearly 2 years. Her rent is £14.50 a month, and her income is only £1,500 a month. Can she get help for accommodation costs till she gets a job? So I think the cap. Oh, go on, Shannon. Yeah.
I was just I can give the figures because I've had a quick Google just to make sure I was right. But it's so if you have less than 6,000, you're fine. You can your AMUC and what have you in savings. I'm not taking in income and stuff, and it won't be affected. If it's between 6,000 and 16,000, you'll be reduced by £4.35 a month. If it's over 16,000, you're not entitled to universal credit. And yeah, so 100k is obviously over 16,000. So they wouldn't be entitled for, and that's the same with housing benefit as well, or housing element of universal credit. So she wouldn't get help with sort of accommodation costs.
Yeah, and not that the person's asking this question, but that amount of money would also probably bar them from getting on the housing register, because most housing registers will have I think in Bedford it's something like 30k for a single person or something like that. So if you've got more than that, you don't get on the register. So yeah, so basically, helpful.
Yeah, I think you're right, and it's helpful as well because it says that till she gets a job. If she gets a job, if she still has over 16,000 in savings, she still won't be entitled for accommodation cost help. So it's not necessarily to do with whether they're working or not. It's about your capital.
Yeah, and so and I mean, I know that the question isn't asked here as well, but if someone with 100k in the bank became homeless, they could make a homeless application. They might well be in priority needs, so they might then have an interim duty to accommodate. but they wouldn't get housing benefit for their temporary accommodation costs, so they would have to pay a lot, because temporary accommodation is not cheap, so they'd have to pay. Yes, you're probably better off in that situation avoiding the council at all costs, because whatever accommodation they offer is probably going to be, you're paying through the nose for it. You're better off going, using that money to obviously, I mean, 100k in a bank, it shouldn't be difficult to be able to source accommodation, basically. So yeah, hopefully that answers that question. Right, next question. There's loads of questions, guys. So, Will and Shannon, if you've got to dart off, you don't need to apologise. Oh, hold on, I've just done that wrong. There we go. So, hi, if a separated couple are working things out and want to return to live together, but the working partner who's on 40k struggling to find a place to rent, can they make a homeless application? So a similar, right, okay, so a couple of things going on here. Again, the problem they've got is if they've got around 40k rather than having 40k as savings. So that's how I read that initially. Now so I guess my question is, where's the other partner living? What's stopping that partner living, moving back in with the other partner who is housed, if I read that correctly. So you are homeless if you have no accommodation which is available for you and your household, and that's a little bit of a grey area. So the household is defined as anyone who is living with you or might reasonably be expected to live with you, which would include family, overnight carers potentially. And I guess I would say it's reasonable to expect an estranged couple to move back in with each other. So you would potentially be homeless. I give an example. So I work with a family. Use this example in training actually. So basically, mum had her one bed. She had like a bed sit, and she had kids who were returning to her care. They both were accommodated on their own, but because they were meant, there's reasonable for them to live together, there wasn't accommodation available for all of them. They were legally homeless. But when it's a partner, a couple like that, I don't know in what situation you would not simply be expected to move in and sleep in the same bedroom. And so I don't see how it would change. So a couple or a single person would be entitled to the same amount of bedroom spaces, if that makes sense. I'm not sure if I'm saying that very well, but so as I say, I don't quite see why the partner who's on 40k can't move in with the other partner who seems to be housed at the moment. That's how I read that question anyway. So again, if they want to kind of just kind of clarify that, feel free. We'll look out for the clarification. And just to bear in mind as well, so there's about a 40-second delay on this, so it's why we're not responding immediately to stuff that's put on there, plus the backlog of questions. So where are we up to? Oh my word. Right. We are we're going to work through this. So sorry, there's a bit more. Okay, then there's a bit more here. So currently both are living separately and have 3 children between them. So okay, if the issue is the children, there aren't enough bedrooms for the children, maybe that might kind of put you into that situation where you would potentially be homeless. But as I say, let me just copy that bit on there. But as I say, I've just pressed the wrong button there. The council is likely to initially basically say, we're going to say that it's not reasonable for you to live together. I've had that argument with councils before, and actually it's quite a difficult one to argue. So I worked with street homeless couples who got together on the streets, and we had to kind of, I don't know if we had to, but we went around the houses and basically demonstrated they had been in a relationship for some time, and that was enough for them to be considered to be a couple. So I think certainly councils need to be very careful legally, because it's not really down to them who you do and don't get into a relationship with. You've got a right to private life, basically. I'm just trying to work out. I've just lost my. Yeah, go on, Shannon.
I guess potentially there could be an unaffordability aspect if the partner who's not working, say, is on universal credit, they would potentially lose their universal credit. They'd have to declare like a joint claim, and then the partner's income would probably mean that their universal credit goes to a nil award, which means then it's the 40k for the whole family. And if the non-working parent is in like a 1-bed, then it's not suitable for the family to move in there. Then the rest of the family moving into that. Do you see what I'm saying? Like, I don't know if it would depend on the situation. Like,
I mean, I think we're probably not able to go into kind of full detail on this one, but certainly then I could foresee situations where you might be able to make a homeless application. if it's not reasonable for you all to live together. There's such a weird way the language works. If it's reasonable for you to live together as all as one big family, and your accommodation is not suitable for that family, then yes, I think you can certainly make a homes application and see what the council say, and then potentially argue them on the facts. So
it could also depend on like so 3 children between them. If say there was other parents also involved, and then they had like main custody, you then or not main custody or main they get the benefits, then potentially you wouldn't be entitled to the bedroom for that child as well. So you might only, and that depends on sort of the blended family setup and stuff as well. So it's probably best getting advice on that one, I reckon, because there's a lot of different elements at play, isn't there?
So next question. I think we probably need to speed things up slightly. So sorry, guys, but there's just a question putting in there. Is there any links to legal aid or housing solicitors in London? Blah, blah, blah. So I put this link into the live chat as well. So this is on Will's blog. So it's basically a list of legal aid funded housing solicitors in London, and many of which will be at capacity. So you probably have to ring them all round and just kind of keep trying with them. But that is a list there that you can use. That's from his website. Next question, is it okay for the council to not appoint a housing officer until 1 to 2 weeks before the Section 21 expires? I would say that that is, I mean, as long as they're accepting the homes application, accepting the prevention duty when they should do, then they do need to carry out an assessment. So it doesn't matter if one says whether or not they appoint a housing officer is not really relevant. The question is they have got a duty to carry out an assessment in a timely fashion, which again is going to be shortly after the prevention duty is accepted, and also form a personalised housing plan. So they need to have done those things. So you can challenge them if they haven't done those things, but the fact that you haven't appointed a housing officer in itself is probably not something you can really challenge, because it's down to the council how they follow the law. They could do it with they could have floating housing officers, whatever. So as long as those things have been done, then it doesn't, whether or not you've got a specified housing officer is not going to really, they can kind of get around that really. I'm sure it's good practice to have a named housing officer who you then go to, but in reality, that's probably not something you can actually, you can't really complain about successfully. So just a question about Oxfordshire, just to give generic stuff, like, so there was a massive kind of postcode lottery about what types of services are available for you locally. So, in Bedford, if you're in Bedford, you go to Just Us, they're going to be the ones that help you out. They're good organisation. If you're elsewhere in the country, it just depends what local services you've got. And you've got to be aware of organisations that are funded by the council. As a general rule, they tend to be pretty ropey when it comes to providing actual competent advice, because they don't want to challenge the council because they don't want to lose their funding. So you need to be aware of who they get their money from.
Can I just butt in there? If the person's on, did I read this rightly, that they're unemployed and or on universal credit? So they wouldn't have to pay, they'd be eligible for legal aid, so they wouldn't get solicitors' fees. And if you're in Oxford, you can still consult a solicitor in London. So, and you can sign up remotely. So the answer would be it's no more, it shouldn't be any more difficult for somebody in Oxford to do it than somebody in London, but that's still difficult.
Yeah. Okay, cool. Next question. If the house is in serious, so I'm not sure, this might follow on from the previous questions we had about Section 20. So Section 21. So if the house is in a serious state of disrepair, leaky roof, collapsed ceiling, broken soil stacks, window falling out of frame, etc., can a landlord serve a Section 21? These are issues reported years ago. So I don't know if we can add much to what we've said already on this, but those are certainly leaky roof, collapsed ceiling. Those are certainly things which are things that environmental health should be inspecting. So if you haven't already, call in environmental health. That's going to be helpful anyway, just to get an assessment of what's going on there.
Simple.
As Will said earlier, for some people, you might just prefer to get evicted, because actually what you end up getting is probably going to be better than a kind of a shanty house, really. But yeah, Will, do you want to?
I just say the simple answer is yes, the landlord can serve a Section 21 notice. The fact that it's been in a state of disrepair and it's been reported doesn't make any difference. What would make a difference is if you go to that checklist at page 10, the things on there, mainly if the council have served a notice, then it's invalidated. But disrepair in itself doesn't invalidate anything.
There's a follow-on question as well, which I'll deal with now. So, so is it? Let's get it on there. So this is about rent increases, but so is it okay for the landlord to serve Section 21 and then offer the chance to stay if you pay an 80% rent increase? I guess the answer is yes. That is legal. It's scummy, but yeah, the disrepair is almost a separate issue. So yeah, again, Will or Shannon, do you want to add anything to that answer?
Just to say, it doesn't invalidate the notice.
Yeah.
If they entered into a new tenancy agreement, it would mean that the landlord couldn't claim possession based on the old notice because there's a new tenancy which needs to be ended. But the fact that they've just said, how about a new tenancy, doesn't make any difference.
Yeah. Okay. Next question. Being homeless, people can have time in their hands as most are not working. What free training resources can you suggest to help people retrain and upcycle their skill set? So, to be honest, our channel is pretty darn good. So that's free. Certain organisations can get free training from Shelter, but if you're in that situation, you're unlikely to apply for it. Shannon, you had your pen up then?
Yeah, I just well, I it's not actually answering the question, so apologies. And I'm not trying to like whatever be difficult. But actually, a lot of homeless people, whether that's rough sleepers or people in temporary accommodation, even if they're not working, probably don't have a lot of time on their hands. Which I know sounds weird, but you are sort of like running from place to place, trying to get evidence, trying to get paperwork, trying to keep it together. So I just want to sort of make that point that, yeah, I guess not all homeless or rough sleeping people are sort of just sat doing nothing. Sometimes it might seem like that or whatever. And I also, again, and this is just, I'm not having a go in any shape, way, or form. Not all homeless people, not all rough sleepers need to be retrained or have their skill set sort of looked at. Lots of people who become homeless have adequate, fine, brilliant, whatever skill sets and training. So I really appreciate the question, and there's definitely situations where like local charities or local volunteer service charities will have brilliant schemes to sort of, you know, get people involved, whether it's in volunteering and then you get upcycle and do skills. But that's not what everyone needs. And it's sometimes actually not helpful. I don't know if I've made sense there, and I'm not trying to like be down on the question. I just think sometimes it can add to stigma and stuff of it's all sorry.
Yeah, that's cool. So there's a question. So question is, can I get answered to question one again? So basically, yes. So someone's already answered in the chat there. So I don't know quite how it happens. The live stream becomes just a video on the channel. So if you go to the live section, I think it's available immediately. Pretty sure it is. You can then go back in time and basically watch that bit again, just a bit missed. So there's another question there which kind of relates to a previous question we had, which if I try and find the right one, we can kind of answer it all in one go. So it's the one that's basically, the housing team's accepting the accommodation is unsuitable. Trying to find it now. Not sure where it went. But basically, I think I want to say, I think we've already kind of answered that additional bit. So if a council's saying that your accommodation is unsuitable, if your TA is unsuitable, legally speaking, they have to move you straight away. So I think it's this one here. So although, again, I think there's some confusion about. Oh man, I'm confusing myself here. I think that's the right. I think I've put the right question with the right next part. So you can be if the accommodation is unsuitable, you can be asked to move immediately. The council, if it's unsuitable, the council's got an immediate duty to move you, irrespective of kind of whether they've got resources or not. They need to find them. If they get into number 5 on the bids, then that's a good sign in terms of you can win a bid on position 5, but that's probably a different question from whether you need to be moved now because your current accommodation is unsuitable. But again, councils break the law all the time, so you need to complain and just kind of lay out the relevant information. Just a little point I say about, I know we're kind of against the clock here. When people make complaints, I've read a lot of complaints people make. Try to separate. Often the things you're most bothered about will be how the housing officer dealt with you because they're absolute bullies. And so that can be the most emotional kind of thing that you've been through. But when it comes to actually writing the complaint, that can often be the most difficult thing to really kind of win the argument on. Try and, as best you can, stick on the objective, relevant things rather than how you felt through the process. No, that's not to negate how you felt through it, but just generally, complaints will probably get a better result if you just really kind of home in on and keep it short what the issue is. So, if someone in this situation, on this date, the housing officer told me that they accepted the accommodation was unsuitable, and yet they haven't moved me yet. That would effectively be the complaint self-contained there. That would be how you go with it. Right, what I'm going to have to do, guys, I think, is just basically say from this point on, we're not going to answer any more questions, and we're going to have to wait, roll it to the next week. We will get through the questions we've had. We're going to be here for some time. So yeah, as Shannon said there, thanks for being patient. Right, next question then. And there's at least two parts. Let me get it all together. Right, I think that's all of it. Someone is in relief duty as landlord did not provide cheaper rent. The council have not found private rent at £1,100 a month. What would happen after 56 days if they're in arrears? The person is in priority needs. The person has local connection, but is afraid because they're in arrears because the rent was unaffordable and they will not be helped. So, yeah, good question. So, if you're in the relief duty, that means the council has accepted you are homeless and you are eligible. So, if you're in priority need as well, that's really good. The next question, the council can, priority, local connections already dealt with as well here by the look of it. So really the only kind of potential stumbling block you have when the 56-day period ends is going to be whether you're intentionally homeless. But if you cannot afford the rent, then it's impossible to be intentionally homeless. Because if you look at chapter 9.7 of the Homelessness Code of Guidance, it basically says you're intentionally homeless if all of the following three criteria apply, and those criteria are you did something deliberately or consciously that kind of led to you losing accommodation, which might include not paying the rent, and it was suitable for, and it was available for you, and it was reasonable to continue to occupy. Now, if you can't afford your rent genuinely, then you cannot be, then you are already homeless. It's not reasonable to continue to occupy the accommodation. Therefore, you cannot legally be found to be intentionally homeless. So, someone in this situation, in one sense, on those facts anyway, can kind of rest easy a little bit because on the information there, the council will owe you the main housing duty if the relief duty ends. They can end the relief duty if they make a final accommodation offer or a final Part 6 offer of suitable accommodation and you reject it. But again, there'll be pretty half decent accommodation options anyway. So, but if the 56-day period elapses, the guidance says they should make the decision on day 57. And the decision in this situation on that information there would be that the person's going to be owed the main housing duty. So there will be a kind of an offer of accommodation down the line that's basically guaranteed. So I hope that answers the question. Again, Shannon will feel free to.
No, I think you've answered that one.
Yeah, cool. I think there's another question. I think I'm going to try and. Yeah, so there's more questions about the kind of the Section 21. Revenge eviction, rent increase type stuff, but I don't know if we can add to what we've already said. But yeah, again, Shannon and Will, if you can see anything else to say on those questions, let me know. But I'm not sure how much more detail we can go into it in this setting.
About revenge evictions.
Yeah, so I'm looking. Well, I don't know. I'm kind of following down. So if you're with me following down, there's basically Shannon's comment which says thanks for being patient, and then there's a couple of follow-on questions there. And in fact, there is a follow-on question which we can add to. So can a tenant sue the landlord for serious repairs that were reported but ignored for many years? So that's a question that's a separate question that we can answer that. So yeah, and I know Will can answer that because you do disrepair cases all the time.
Yeah, they can. The thing to bear in mind is that legal aid is available to take legal proceedings to get an order to require the landlord to carry out the works, but it's not available to claim compensation for the failure to carry out the works. So if you were in a situation where you spent the last 10 years trying to get the landlord to do the works, and then they do the works, you're not going to get legal aid, even though you might be entitled to large amount of compensation. because it's simply out of scope. But you might be able to persuade us. There are solicitors out there, particularly in Liverpool, who will do no win, no fee claims for compensation. I don't know why they're all in Liverpool. My family are from Merseyside, so I'm not being prejudiced, I promise.
But presume that you can, yeah, even if you don't live in Liverpool, you can still go to them, yeah. So
yeah.
So you're not restricted.
I've got a client in London who's got a case going on with one of them, but they had to stop it because they don't do possession, and the landlord sued her for rent arrears possession, and she needed to counterclaim for the disrepair.
And I'm right in thinking there is actually quite a lot of money. Like if you win, there's a quite substantial payments. Is that right, Will?
Yeah, I mean,
like,
basically,
as in like 5 figures.
You could be looking at thousands. Yeah.
Yeah. Okay. Right. So, next question: family of 4, want a suitability review. Well done. Good work. And put on transfer database. Lived in Westminster for 14 years, but in hostel outside it. Mum's a carer and son is over an hour away from school. Any ETA estimate? Have I missed a bit of that? Hold on. Just go back a step. So there's a bit, yeah, there is a bit more. Hold on. So I think they're saying estimate on how long it's going to take. I'm not quite sure what the question is there. Mum's a carer too, but is over an hour away from her care recipients and has to commute. Overcrowded hostel, no space at all. Entitled to 3-bedroom, but given 2-bed hostel. So yeah, okay. So there's a few, obviously, a few things going on here.
There's one more part to it as well. Sorry.
Okay, cool. Well spotted. Hold on, let's get that bit as well. Do you mention if your housing officer has determined the TA to be unsuitable in the review, then you have to legally that I mean not instant that second, but within a couple of days is my guess. So I think if it went to court, judges would kind of say, okay, the council need a couple of days at least. So so you can absolutely complain. So family 4, I'm going to guess there's children involved. Without reading it all again. It sounds as though if it's a hostel, if it's shared facilities, then it's likely to be classed as a B&B, and therefore you can only be housed in a B&B for more than 6. Or you can't be housed in a B&B for more than 6 weeks if you've got kids or a pregnant woman in the household. So you need to complain. Go on the YouTube channel. Go on this YouTube channel. Search for. I don't know. Just go through the recent videos. I did a video specifically about not only how to complain but also how much to ask for, because the LGO recommends £100 to £200 every week you're in over the limit in B&B accommodation for more than 6 weeks. So you could actually end up being a lot of money. Now that's that element of the question taken care of. Where in terms of caring responsibilities, the key thing the council need to have done is actually considered the impact on those individuals. So there needs to be a record of them actually saying, okay, well, the mum lives over an hour away, and we think that's suitable because of X, Y, and Z. They probably haven't done that. So if you make a request for your records, subject access request, if you Google subject access request ICO, the letters ICO, you'll get the ICO website, and that's got a service now which allows you to make a request to Westminster or any council or any organisation using their website. If you just fill in a few details, you probably want to get the copy of their records, and you can raise it in the complaint. So again, you want to raise the complaint now. Run through the complaint process. Stage 1 will probably be knocked back. Stage 2 might be useful, but then you get to the LGO. The LGO would actually look into those issues as well, and I think they might, if you raise it as an issue saying the council housed me too far away from my support network or whatever, too far away from school, then the LGO might be able to make a finding. We've talked about this before. If you Google guidance, school transport, home to school transport guidance, something like that, there's a document from the government which basically states that primary school age kids should be no more than 45 minutes away from school door to door, not just the actual the train journey or whatever, but the actual door to door journey. And secondary age kids can be no more than 75 minutes from their school. So just have a look at that, because again, you might want to use that within the complaint. So, so I'm where are we up to? I think we've done that one. My voice is going, I'm melting, but we're going to keep going. So here's the next one here. Oh, no, it's not. Come on. So, gosh. Here we go. So my friend has been put in a travel lodge as interim accommodation, but due to gatekeeping treatment in in which her health was affected by it due to she fled from the interim accommodation, and helping let's try and just kind of get this all together. So this person's helping someone else who was put in Travelodge accommodation as interim, had an impact on her health because she was initially gate kept, managed to get a solicitor. We explained all the situation before the letter was written to the local MP, received a positive reply. My question
There's two
is,
more, I think.
yeah, thanks, Shannon. So let's just, my question is, a house was offered by local authorities, what she needs to watch before signing the lease, please. Okay, and there's a bit more. So well done for getting the MP involved. That's a good move. Not all of them are any use, but some of them are. Do we also let the MP know in the solicitor due to the fact she's been tricked before by a housing officer with no power of choice and unfortunately so okay, yeah. So when you anything you sign with a housing officer, you definitely want to get, if you can, get some legal advice on it, because yes, some housing officers do trick you into signing stuff which is ridiculous. So you want to be very, very careful. And if you look at the code of guidance, it basically talks about how council should give reasonable time for people to consider offers, so they should give you time to go away, have a think about it, digest what's the offer is, where it is, what kind of, what, all the details of it before having to sign it. If they're putting pressure on you to sign it, just tell them to do one and just say, no, I need time. And you want to put it in writing. So you want to write to the MP saying, this housing officer is making me make a decision within 10 minutes or something, can you help out? Just so it's all in writing. So I think, yeah, you want to kind of basically make sure you know what you're signing up to. That's the kind of the short answer is. I think that's answered it. But yeah, I completely get why housing officers basically, by acting, or by many housing officers acting unlawfully, it means you don't trust anyone, and I get that. It's one of the reasons why they shouldn't do it, but they do it. So yeah, so Shannon and Will, do you want to add to that one at all? So we're not going to take any more questions through the live stream, but they're asking.
And they've asked the question: do we mention this to the solicitor? And I'm sorry if I missed it, and you said yes. I mean, yes, of course you do. That's what they're for. It may be that they'll say, don't worry about it, but definitely raise it.
Yeah, in writing as well. Do everything in email if you're not already.
Yeah.
Cool. So, right, there's a few more questions you've had in through the week that are not anonymized, which is why we save it to the end. So all the more reason to anonymize stuff. So here's the first one. I'm trying to place a client into support accommodation. They mentioned the rent will be cut. In fact, this was anonymous, so I apologize for that. I just saw that I'm trying to place a client into support accommodation. They mentioned the rent will be covered by housing benefit from the council, but told me to be accepted, he needs to be in receipt of universal credit. Any idea why this might be, as the rent would not come from UC element, but from HB? He does a bit of cash in hand, so could easily cover service charge. Yeah, so basically cash in hand, income needs to be declared. That's really dodgy. You can't be sort of saying, oh yeah, that's all right, mate, because if DWP find out about it, they'll be on them and say, you've been earning money not telling us about that. So or housing benefit would be, or whatever. So yeah, you need to be in receipt of UC. You need to declare your earnings. And I get it. Universal credit is not too bad when it comes to formal work. So if you actually invoicing for it and stuff, it's not too bad. Shannon, do you want to add anything to that one? Because yeah, you know way more about DWP than I do.
I guess there's nothing stopping the cash in hand work with the person being on UC. Like, there's still a way to declare that on UC. But the real difficulty is going to be declaring it to housing benefit, to be honest, because you in a situation where you're in support accommodation and you've got universal credit and housing benefit, you have to declare it both separately, which, I'll be completely honest, is a massive pain, and it's actually quite stressful. So I guess just make the person aware that they'd have to sort of declare it both to UC and housing benefit, not just universal credit. But universal credit in and amongst itself wouldn't stop the cash in hand work, because you'd still declare it. It's just through another way in the journal. It is slightly more difficult, and potentially it will affect like the work commitments. But I'd assume if they're in support accommodation, there's a reason. that they're only sort of maybe able to do cash in hand work. That's not sort of unusual, I don't think. So explaining that to sort of empathetic work coach is probably your best bet. But I'd
Yeah,
also maybe if this is going to be a barrier, yeah, I'd look into maybe why they need supported accommodation and why they couldn't potentially get housing through other routes.
yeah. I mean, one of the main problems with supported accommodation is the fact it's so expensive if you're working. So, and just to make the point, it's some sort of fraud that, you know, if you're taking cash in hand work, not declaring it and then claim benefits as well, it's a crime. So don't do it, basically. Cool. Next question. Again, I think this is an anonymised question, which I thought was not anonymised. I have an interesting case. Section 188 was discharged after the client declined TA based on medical unsuitability at the single ensuite advertised as a studio. The council haven't completed a medical assessment and aren't medical professionals. However, discharge support and inform the client she's responsible for finding her own accommodation. The client is currently incurring debt, paying her own hotel accommodation. What would you recommend in this instance, keeping in mind there's sufficient medical evidence to support the case? So, just to say, if you turn down Section 188 accommodation, that doesn't mean the council's job has ended. They still need to continue the relief duty. They need to make a decision that, you know, whether or not you're owed a main duty. If you've got these kind of medical issues, you're probably going to be in priority needs, so you're probably going to be owed the main housing duty in most cases. So, but yeah, I mean, so the only problem you got here is that challenging the suitability of Section 188 accommodation can only be done through the courts. You can't challenge it through the review process, which is a shame. So although you might have really good evidence for it not being suitable, my understanding is you'd have to get a solicitor to kind of take the argument to the council. Will, do you want to correct me if I'm wrong on that one?
Yeah, that would be by way of judicial review proceedings. Yeah. So you could do your own judicial review, but it's not easy.
Yeah. So Will and Shannon, if you need to go, just go, because I appreciate this is way overrunning, and we've got a lot of questions left. So next quick, I'm going to try and do them adequately, but as quick as we can. I'm 25 years old, live with my mum and siblings. I've been wondering if I was able to apply for council housing, one bed, flat or studio. Will I be eligible, or is it hopeless and should I be looking at private rented? So it's not 100% hopeless. You can get onto some housing registers. Again, make the point, they're all different over the country. You can get onto some housing registers in that situation. You might be overcrowded, might get some points for that. But if private rented accommodation is an option, that's the one that's going to get you something fast, because if you can get onto the housing register, you're likely to be a very low band in that situation on that information. So unless you're living somewhere like Shropshire that Shannon mentioned earlier, like the Rare or the Sticks or whatever, then you probably haven't got a hope in hell. If you're in London, you probably haven't got a hope in hell of getting anywhere. So yeah, go down the private rented if you want to be housed anytime soon. But again, you don't lose, it doesn't cost money to apply for social housing, so you can do it. Just see what they say, and you can also FOI, as in freedom of information request, the average waiting times for people who would be in your band who need a one bed house. Next question is a long one. I'm going to try. I think, and I'll try and actually kind of home in on the question here, because there's a lot of information which isn't necessarily gonna really kind of add much to the question.
I'm still here. I am just going to take a quick bathroom break while you guys are doing that one.
Yeah, cool. Yeah, nice and cheers, Shannon. I'm going to put the whole question in, but as I say, there's a lot of information here which, as I say, kind of doesn't change the actual answer. So, it's been homeless in the tent for 3 months. Council gave me a deadline, 10th of July, to rebut their investigation claims, namely an assumption to prove my case is genuine. So basically, it's a case involving domestic abuse, which seems to be kind of financial abuse, potentially, coercion and control, maybe emotional abuse, those types of abuse, which are very real, but also quite difficult to prove. What steps can be taken? As I've asked for an expected date on their conclusion to the investigation since 21 days, so 57 days has lapsed. So if the council is basically saying you're not at risk of domestic abuse, that's what they're saying, they don't, the relief duty doesn't continue, it just finishes. So there's nothing else they can do. The only thing you can do in this situation would be to either challenge the council and say, you're wrong about me not being homeless. I am homeless. I am subject to abuse. I'm at risk of abuse in my home. these are the types of abuse, this is the type of impact it has on me, that's kind of information that's going to be helpful. Therefore, I am homeless, therefore you need to treat me as I'm homeless. Or you make a fresh homeless application based on the information they didn't consider the first time. But the same argument, you're still making the argument that you're at risk of abuse, and therefore, therefore you kind of the council's got a duty to accept an application. If you're homeless because of domestic abuse, then you're automatically in priority need. So the council should, in most cases, basically be housing you in interim accommodation straight away. If there is reason to believe that you might be at risk of domestic abuse, that's how the law would work. So you can also, it's not going to hurt to make a subject access request to actually see what investigations they've made, what decisions they made. I'm not sure. So Shelter, I've emailed Shelter and they've involved, and I think maybe, is this St Mungo's? Maybe, I'm not quite sure what this word is here. All these agencies are like the IPCC. As we know, okay, so I'll say a couple of things about Shelter. I don't know anything, I've never dealt with St Mungo's. If it is St Mungo's, Shelter provide excellent advice on their website, and I think some of their advice services are great. They do take money from local authorities, so the only direct contact I've had with them was a pretty shady one, really, where they basically held, they did a secret shopper report at Bedford, and the actual evidence was pretty damning. The council was systematically gatekeeping people, and yet sort of Shelter wrapped it up in the nice kind of wording and made it look like the council were doing a good job. But that's all I've got to say about Shelter. So yeah, some organisations are shady, some aren't, and some big organisations, there'll be great people there anyway. So it's probably not wise to kind of write off the whole organisation. So yeah, I don't think this additional stuff here changes what I'm saying. So make a fresh, either challenge the not homeless decision or make a fresh application and get as much information as you can. You've already got supporting evidence from family members. If you've got in contact with any professional services, you might be, went to the police because someone was trying to steal your car or whatever. Put that all together and kind of make the argument again and challenge, basically, and challenge it again. So I think that's all I can say about this. Shannon and Will, do you want to add anything to that?
No.
Cool. Right. There's like 3 questions left. Some of them are really easy. So, what is the difference between Section 189B Housing Act relief duty and Section 193 Housing Act? So Section 189B is all about the relief duty. Section 193 is all about the main housing duty, as in the kind of the duty that applies to people who are in priority needs. They're homeless, they're eligible, they're not intentionally homeless, and for sake of argument, they've got local connection, or it's more complicated than that. So the council can make offers of accommodation under both Section 189B and Section 193. If I was homeless, I'd want the Section 193 duty. Then goes on to say, I've two different letters. One of them says council has ended the duty under Section 189B2, but I've asked to review the council's. Okay. I think what this is saying is that maybe you rejected an offer of accommodation that was made available in the relief duty, and therefore they're saying the Section 193 duty doesn't apply, is my guess. I don't think we can say anything more about that based on that information. But yeah, have a look in the Code of Guidance in Chapter 14, because you might have some information that's going to be helpful there. Right. 2 questions left. This one's easy. Can I make an application for housing register in a different council without having any local connection? Yes, you can, but you probably won't be eligible for it. So you can apply anywhere, but most, if not all councils, I say most, they'll have a restriction, which basically means you need to have a local connection there. You can make a homeless application, and if you're homeless, and the local connection definition works differently. So it's easier to make an application under Part 7 if you've got no local connection rather than Part 6. And finally, so I've requested for a subject access request, still waiting, but council has given me Band C, homeless duty. What does this category mean? Band C waiting time is the longest one, but it says Band C and within the brackets of homeless duty. So you'll either be under relief duty still, or you'll be owed the main housing duty, either of which could be Band C. It just depends on your local policy. So yeah, I'm not sure if we can add anything to that. You need to check out the local housing allocation scheme just to see what it says. Yeah, that it's just basically saying they have a policy. You've been accepted as homeless in some way, whether it's relief duty or whether it's main duty, and therefore you need to be in that band. And yes, it might be the longest one. It just depends on the council's policy. That's it, guys. Oh yeah, go on, Shannon. Yeah, I'm tailing off. You can tell.
And I'm the bad one who's asking for homework. With the SAR though, and it says still awaiting. Sort of, if you're still awaiting within the time period, fair. If it's the time period has elapsed and they're supposed to have completed it by now, you can basically email. I think the ICO's website says wait a week, and then they've got like a template email. You can email them chasing it, and then you can complain, and then like, follow it on from there. So, in regards to the SAR aspect of that, and I know they've not asked a question, but I'm assuming there's some relevance. Like you might need it to try and get your banding up. That's what you can do in that situation. I'm going to stop talking now because we've reached the end of the questions.
Yeah. Okay.
Yeah, one thing, yeah. You want to go, but did we answer the question? I'm sorry if you did and I wasn't listening, but I think I have been. But the did we answer the question about will the council help find a place with a garden?
No, because that was after Mike's cut-off point.
Oh, was it?
That was after Mike's cut-off point.
Okay, so
but it's whether we now answer it because you've brought it up.
Well, just to say no, they won't. Just because you've got pets and mental health problems, but if your mental health problems mean that you need pets like is it a comfort dog or then the question of a garden might be a requirement for the accommodation to be suitable. But just the other thing is if you've got children and the children have special needs, then you could require a garden. For instance, if the child has autism and behavioural problems, which mean it's difficult to play in a park or something, then a self-contained garden would be an essential thing for suitability. So that's it.
All right, guys. Yeah, so there are a couple of questions that are coming after the cut-off point. We just say, can you ask them again next week? So we're sorry we haven't had time to do it tonight. We've been going nearly 2 hours. I'm absolutely sweating horribly here. So yeah, keep the questions coming on the channel. Again, if you find this stuff useful, do like and support the channel. It means a lot to us. I'm hoping this stuff does help. But yeah, we'll be back on next Thursday. Will and Shannon, you around? You're going off to your travels on you at some point, Will?
I am. I'm going to the Isle of Man on Saturday, but I could take my computer with me and join you next Thursday, hopefully.
Well, I mean, you'll be answering your emails, mate. So yeah, just have it off, mate. Yeah, take a break.
I'm away for 2 weeks, so maybe I'll join the second one. But no, okay, all right, I'll leave it.
Yeah,
I do enjoy these sessions. It's not like it is. It's not easy, but it's not work, if you know what I mean. It's a pleasure to do. But anyway, yeah, I will stay away and see you in 3 weeks, I guess.
Yeah, cool. Well, I hope you have a great time.
Thank you.
Yeah, cool. And for those, to say, for those who kind of didn't get a chance to get your question answered tonight, just ask it again next week. We'll try and work through it. And again, if things continue on this vein and we have this many questions in, we'll work out some of the way of doing this, like whether we do 2 a week or something, but we'll figure it out. But yeah, hopefully it's been useful. And keep going. Basically, it does work. Just keep sticking at it. Don't be afraid to challenge councils. Yes, they break the law a lot, and really what they're waiting for is for someone just to give a robust challenge. And a lot of the time they'll just roll over if you kind of stick with it for long enough. So yeah, hope it's useful, guys. See you soon.
Bye.
Hold on, Will. We're still on. I've got work.